Welcome, Craig. Today we're going to talk a little bit about tenancy, so it's great to have you with us just to lend you a bit of your expertise.
Pleasure to be here.
So if we could just talk a little bit about general tenancy legal issues. When renting, in what sort of situations might I end up needing legal representation and coming to someone like you?
So, I mean, it depends really. I mean, we can get all sorts of various issues. It could be struggling to pay the rent. It could be that they're having problems with the landlord getting things done in the property, repairs not being done. It could be that they've got an issue with any kind of part of the contractual arrangement that the landlord isn't holding up their part of the bargain. And it's really important actually that they get that advice, or they understand their position as early as possible. The longer they leave it go, the worse the situation generally gets.
Absolutely, and I suppose you see people at all ends of the process where it's really early engagement to right when it's a bit too late to come to you.
Yeah, I mean, I always prefer people to come to me sooner rather than later. It's always a bit easier for us to help them if they get early advice. Generally, if they've let things drift, then there's a lot more that we need to do to try and catch up and rectify the situation, and sometimes makes it even more difficult to resolve the situation for them if it's possible of being resolved.
From a tenant's perspective, what are the telltale signs that the problem has become a legal issue?
I suppose when you raise it with your landlord, every tenant should be able to contact their landlord freely in line with whichever agreement they've got to raise an issue. And if the landlord becomes difficult, or things don't get fixed, or things don't get sorted, then that's probably when you might want to seek advice, particularly if it has quite an adverse impact on the way in which you can stay in a property, whether that be damp issues or simple repairing issues, leaks, things like that.
Would you advise when you're contacting your landlord to keep everything in writing, keep a record? Is that something best practice-wise?
It's best practice. It depends on the relationship you've got with the landlord. If you've got a pretty good relationship, then a phone call should be enough to resolve something. But a text message, an email, if they're using an agent, probably better to go via email so that you've got that record, because agents are representing so many landlords, they've got so many on their books that it's quite easy for them to lose a record of something.
Yeah, best keep a good audit trail
Yes,
and help makes your job easier,
yeah,
doesn't
absolutely.
it? Do you find there's any areas where your clients are underprepared when dealing with legal issues, or areas where there's a lack of knowledge? When
it comes to repairing obligations, they don't understand what they can do to resolve it. They think that the landlord owns the property, the landlord can get away with whatever level of repair it is, but actually there's a standard that the landlord will have to meet. The tenant has a right to have a property that is fit for them to live in, and sometimes they don't really appreciate the steps they can take to force a landlord to maybe carry out those repairs as quickly as they should. And it's interesting because the law is different between England and Wales in terms of housing law, and so landlords and tenants, in fact, have to really be sure as to what their legal position is, because there are differences not only between England and Wales, but also between different local authorities, different areas as well. If someone is renting a property and having issues, what options are available to them for gaining knowledge and accessing advice? Well, there's lots of resources available online these days, as with everything. I always err a side of caution in terms of how much you trust those online resources, but there are lots of landlord and tenant associations that you can access advice on, citizens' advice, shelter. And quite often you might even be entitled to legal aid to get that early legal advice as well from various legal aid solicitors. There are plenty of resources out there. Nothing is better than getting in touch with the earliest opportunity and making sure that the advice you're given is the right advice, rather than trying to do your own research and trying to understand which of the various laws that there are apply to your situation. So it's making sure that the online information actually applies to you, because there are so many differences in the law for landlords, tenants alike, between England and Wales and other areas, that quite often you can get confused by certain laws that you might think are applicable to you, but actually they apply to someone in a different area, a different situation completely. Absolutely. Can tenants represent themselves when it comes to legal matters? They can. I wouldn't advise them to, because the law is so complex. It's always advisable to get legal advice and legal representation, not least because of the potential consequences, particularly if you're looking at facing possession proceedings where you're facing losing your property, losing your home. And one of the other places, of course, that the tenants could go to is their local authorities, housing department as well, where they might be able to get some advice, because they have the duty to discharge in terms of homelessness. So if people are at risk of losing their home through possession proceedings, then they can go to their local authority as well.
How do you get the most out from your legal representation as a tenant?
I think it's making sure that you keep a record of everything, make sure that you've got all the records that you need, records of conversations, records of email correspondence, photographs of issues, and just try to keep as much information as possible. It makes our job a lot easier when a tenant comes in and they've been able to show us all of the history of the matter and have a record of it, rather than us having to rely on preparing witness statements that perhaps aren't supported by any evidence.
Yeah, I suppose sometimes a problem can arise and you haven't gathered any evidence. What can you do in those regards? Can you advise them on the types of evidence to get?
Yeah, absolutely. So if people come at a stage where maybe they haven't thought about that yet, they can start at that point. I mean, it might not have the full picture, but at least it's better to have some of the picture rather than none of the picture.
Absolutely. If we just change course a little bit, just to cover from the English law point of view and the Welsh law point of view, how can a tenant find out what their rights are before, during and then after renting a property?
So again, there's lots of information available online, but if a tenant wanted to get specific advice on the situation or their specific circumstances, they could approach a solicitor, or again even the Citizens Advice Bureau or any other organisation, shelter, to get that advice on their rights and obligations. But the starting point will always be their agreement, that their individual tenancy agreement, or in Wales the occupation contract. That will be the starting point for them. So if they go to that source document, that will hopefully give them the information that they're looking for, because most of the law will be brought into that if it's been drafted properly.
Do you always recommend they come to see a solicitor before they sign that tenancy agreement?
It would be advisable. It's not always possible, but certainly if you're entering into a binding contract that is going to have potentially adverse consequences on you in terms of the sums you have to pay, your obligations under that contract in terms of how you have to treat the property. If you don't really understand that, then it's always best to get advice.
What are the key things tenants should think about when it comes to protecting their deposit? How can they get educated on their rights?
In terms of protecting the deposit, it's the landlord's responsibility to do that, not the tenant's. And so when the tenant is paying a deposit, there should be within the tenancy agreement a specific clause that deals with what is going to happen with that, and the tenant should be given by the landlord prescribed information which sets out exactly what's happening with the deposit, where the deposit's being kept, and what they can do if there's a dispute in relation to the deposit. And they have to be given that information within 30 days of the start of the tenancy, or within from the deposit being given. So they should make sure that happens. In terms of getting educated about that, again, it's about seeking advice, and if you're unsure about what your rights and obligations are in relation to tenancy deposits, whether that's from a landlord or a tenant's perspective, the best solution is always to seek the advice of someone that knows what they're talking about.
What are the key things tenants should be thinking about when looking to rent a home? How can they find out what their rights are?
Again, there are lots of online resources. There's the availability of solicitors, Citizens Advice Bureau, all of those people that I mentioned already. The tenancy agreement is what will dictate, and the occupation agreement is what will dictate their rights and responsibilities under that specific agreement. In Wales, there are now standard occupation contracts, whereas in England you still have tenancy agreements. There's now a standard document in Wales that every landlord has to give to their tenants, whereas in England there's going to be all sorts of different varieties and different terms and obligations under each agreement. So it's really important that people understand what is in their particular agreement before they sign it, because as soon as you sign that agreement, you're effectively binding yourself for whatever period that agreement is for, unless there's a mutual agreement between the parties to bring that to an end.
Tenancy agreements, what are they, and do you need to get legal advice when signing one or wanting to amend it?
You don't have to, but it's always advisable to. They are contracts that are enforceable and the terms within each agreement are enforceable. So you have certain obligations as a landlord, you have certain obligations as a tenant, and if you breach those obligations, you're liable to being pursued for a breach of that contract. If you're a tenant and you breach certain contractual arrangements, then you can face possession proceedings where the landlord can seek to obtain possession of the property back from you for breaching that contract.
Yeah, so it's worth, even if you don't get legal advice, just reading it really clearly,
Yes.
making sure you understand all the terms and conditions.
Absolutely, absolutely.
Yeah. If you're worried about eviction, how can you find out about your rights and where can you turn for legal advice?
So the best thing that someone could do if they're facing eviction is to get legal advice immediately. The longer they leave getting that legal advice, the more difficult their position will become. If you can't get legal advice before you end up at a court hearing, generally most courts will have a duty solicitor that's funded to be able to offer some assistance at the court, but that's not always available, so it's always better to get to a solicitor sooner rather than later.
Yeah, it could be a really anxious time for many, so really key to get someone who knows what they're doing.
Definitely, and without that advice and without that support, you might not achieve the outcome. For example, there are lots of obligations on landlords to comply with certain legal requirements, whether that be protecting deposit or being registered with a scheme such as Rent Smart Wales in Wales and being licensed as a managing agent. And without that, if they haven't complied with that, they're not able to serve the correct notices in a valid way, which could mean that if they issued proceedings against you, you can defend them on that basis and have those claims dismissed. Without getting that legal advice, you might not understand what you can do to defend those proceedings. Just because a landlord is pursuing a possession action against you doesn't mean that they're going to get possession ultimately.
Yeah, so it can be really complex.
It can be.
Yeah. If we just move on to eviction, if someone's renting a property and is worried about eviction, what options are available to them for gaining knowledge and accessing advice?
Again, the first thing would be a solicitor. The obvious option would be a solicitor, someone that is qualified and has experience in this area of law. Their local housing department in the local authority, they'll be able to give them information as to potential alternative housing stock, give them some advice on whether or not the notice that they've been served with is valid, maybe even contact the landlord on their behalf to query things, and you can get some support through your local authority, which can involve potentially finding alternative accommodation for you if that's ultimately where it might end up. But there can be really no replacement for obtaining legal advice.
Do you need legal representation for dealing with eviction, or can tenants represent themselves?
Tenants can represent themselves, and quite often they do, but I wouldn't advise that. They will need to obtain advice as early as possible. Whilst they can represent themselves, they won't be able to identify, I say won't, but they're unlikely to be able to identify all of the potential defences that they have to a claim for possession and potential eviction. A landlord can't evict a tenant without a court order, and if there are any defences or any grounds upon which that possession order shouldn't be made, then a solicitor will be best placed to identify that. Some tenants do represent themselves quite successfully, of course, but I would always advise getting legal advice as early as possible and making sure that you have a solicitor represent you at that hearing and at that process.
It can create quite an intimidating atmosphere in eviction as well, so it can be quite nerve-wracking.
Definitely. If you're turning up to court, a judge will generally dedicate 10 minutes to decide whether or not you're going to have to lose your home, which is an inordinately short period of time. But generally all of the possession actions are based on facts that have already been presented in the papers to the judge, and so their job is simply to understand whether the grounds for possession have been met, whether that be through the accelerated route because of a Section 21 notice in England being served, or the new notice in Wales being served, or for breach of tenancy. The judge has a very limited period of time to consider all of that and make a decision whether or not possession should be given.
What are the key things tenants can do to protect themselves when they start to become worried about an eviction, or even before they become worried?
Don't bury their head in the sands. That is something that sadly does happen and just makes things worse. You've got to confront it, address it and deal with it. Landlords generally will want to work with you to, if there are rent arrears, for example, they all want to work with you to understand why
Yeah.
and to come up with a solution to stop that happening and to resolve the situation. Because ultimately they want you to be there, particularly if you're a good tenant. They're not going to want to lose you, but ultimately they will need that income and from the property to be able to carry on.
Yeah.
But the best thing they can do is just deal with the issue, get some legal advice, not ignore the situation,
Yeah.
because the longer they ignore it, the worse it will become.
I suppose early intervention before that critical communication breakdown is key.
Yes.
Yeah.
Because a landlord can decide whether to pursue you for possession proceedings,
Yeah.
but if you're in communication with them and trying to resolve a situation, then quite often that can resolve it without getting to the stage where you find yourself in a court hearing having to
Yeah.
defend why you haven't responded to
Yeah.
various complaints or various issues.
Yeah, and you can save a lot of money not going to court.
Absolutely.
Yeah, with early intervention. In terms of the issues and complaints, what are some of the most common misconceptions on the part of tenants who think they can take action against their landlord?
Tenants generally aren't completely aware of what a landlord is responsible for, and so the best thing they can do is to really understand what the tenancy agreement requires the landlord to do. There are certain implied covenants into a tenancy agreement that is derived through statute, but generally they will be expressly in that tenancy agreement as well. So going back to that tenancy agreement, understanding what their obligations are, but also what the landlord's obligations are, because quite often your answer will be in that document.
Yeah, and I suppose it differs case by case based on what that tenancy agreement is.
Absolutely.
At the time.
I mean, in Wales, it's in a bit more. It's a different position in Wales now since the 1st of December last year, where there's the standard occupation contracts. I mean, there will still be some variations to those, but largely they're going to be more or less mirrored between tenancies.
Yeah.
But in England, where there are lots of different versions of tenancy agreements, lots of different standards of tenancy agreements, some will be quite well drafted, others maybe less so.
What's the difference between your matter not turning out as you hoped and having grounds to complain about your legal advisor on the other side's legal representation?
Quite often, you don't always get the outcome that you're hoping for. By having early legal advice, your expectations can be managed. So your solicitor should give you advice on what the possible outcomes are so that you're familiar and aware of what could happen. Ultimately, if you're in a position where you're facing court proceedings for possession, for example, and you end up going to court and you lose possession of the property, your solicitor, before you get there, should have advised you on that being a possibility so that you're prepared for that and explain why. Your solicitor should be able to give you a reason and give you a fairly good idea as to what the potential outcome is likely to be. However, if a solicitor, for example, hasn't told you that you were at risk of losing your home when you're going through that process, then of course that would give you grounds to complain and raise issues with that solicitor.
Yeah. What can you do if you think your legal representation isn't doing a good job?
The first thing that you can do is to have a discussion with that solicitor and be frank and honest with them as to what your concerns are, because it might be that there's a valid reason as to why certain things are being done in a certain way. If you're unhappy with that particular solicitor, then you can always complain to their superior or raise a concern with their superior, and there might be other fee earners within that department, within that firm, that perhaps the matter could be transferred to. And if the matter can't be resolved that way, then you could always maybe seek representation elsewhere and find another law firm.
Thank you so much for your time and your expertise, Craig. It's been really useful just learning the difference between the English and Welsh law, so really fundamentally helpful. Thank you so much.
Thank you.
Thank you.